Hi, I'm Harvey Blankfeld of the Brown Blankfeld Group, Berkshire Hathaway Home Services of Nevada. And we want to thank you for choosing the Brown Blankfeld Group for your real estate needs. We have prepared this video for our clients so they better understand the documents we use. And while we don't review every section of the document, we do try and clear up some of the most relevant concerns. We are recording this video in March of 2020. And if you're watching long after that date, there are likely changes that have taken place with this document. And this video may have some parts that are outdated. Also know that we operate in Southern Nevada and these forms are specific to our market. While you may be able to glean some value from this video, please know that no two markets operate exactly alike. And finally, I need you to know that I'm not an attorney and none of what I'm saying should be interpreted as legal advice. The Residential Property Management Agreement. This is a document provided by our local board, Las Vegas Realtors, for us to utilize when we have a homeowner that wants us to manage their property. So let's just get into it. This is a 12-page document, and here on page 1, right at the top, we're going to start with just the filling out to the date we did the agreement, the 23rd of March in 2020. Here's the homeowners of the property. Here's our broker, Forrest Barbie. This is our company, Berkshire Hathaway, and then this is me, the assigned agent, the authorized agent for this particular agreement. And this is my property management license number. In Nevada, we're required to have a separate permit to do property management. Not every real estate agent can do it. Only those who with a special permit can do that. Now, notices are to be exchanged between the two parties, and this is their contact information for the homeowner, and then the contact information for us, the brokerage. Very simple. All notices need to be exchanged between those two contact points. Basically, this first page, the bottom of it, we're talking about that the owner is employing us to be the sole agent of them, to act on their behalf, and the relationship is that of agent, that we are in fact an agent of the owner and we're there to act on their behalf and in their best interest. It's an agency relationship that enables us to do things on behalf of the owner to make sure the house is in good working order and to get, basically it's a fiduciary responsibility to the owner to make sure things are all done properly. Description of the property to be managed. In this case, there's an attachment. Exhibit A is at the very end of this agreement. That's the final page of the agreement. And in that describes the specifics of the property. Now, there may be more than one property, which is why it's done that way. And if it is more than one property, you just add an additional Exhibit A to the agreement, and that could add a second, third, or fourth property, so forth. Now, at the bottom of each page, you're going to see the name of the homeowners, and this is on the bottom of every page. This is where I will initial as the authorized agent for the broker, and then the owners will be initialing down here to acknowledge their acceptance and understanding of this page worth of details. Page 2, the term of this agreement shall be for 1 year. It starts on April 1st and ends on March 31st of the following year. Our compensation, broker's compensation, management services, in this case, we're asking them to pay us a minimum of $100 per month or 10% of the monthly gross rents. There is no, while we have the opportunity to charge this, we don't. A vacant property fee, in our case, we don't charge that. The leasing fee, we charge $800 or 5% of the first month's rent. Again, whichever is greater. And normally it's $800 for most cases, and every once in a while we have to charge a little bit more. The setup fee, we don't charge that. We're given an opportunity to do so with this agreement, but we don't charge anything. The referral commission, this is the amount of referral we pay to the agents that bring us your tenant. That $300 actually comes out of this $800. So we actually end up with $500 in our case. But that's what that's for. Lease renewals, again, we're given the opportunity to charge more for that. We don't. You can see I put zeros in all of these numbers. I don't charge for lease renewals. Advertising, we could in fact charge you to advertise the property also, but again, we don't. That's all included, the way we see it, that's all included in the fees we do charge. The only two fees we charge being the management agreement, the management fee of 10%, or the leasing fee of $800. If there's any sums that are not paid to us in a timely manner, we can charge interest, 12%. Extraordinary services, we charge $75 for extraordinary services. I've never actually charged this, $75 an hour, but it would be for things above and beyond our normal course. And they're giving an example of HOA meetings, compliance hearings, or ombudsman's hearings. We could charge $75 an hour. Again, I've never charged it. We've never charged that. Termination fees. There could be a termination fee If you, as the owner, want to terminate the agreement early, there can be fees involved. If you terminate it at the expiration, there's no fee involved. And then if there's a need for us to make a collection from a homeowner, we could charge additional collection fees. Again, never had to do that. Bottom of this page, as with every page, I'll initial here, and the homeowners will initial right over here. Moving on to page 3, we will be maintaining a trust account through our brokerage to handle all the funds for your specific property. We are obligated to reconcile that every single month, and we do, and the state monitors that account very closely. So we do everything by the book at Berkshire Hathaway. Initial deposit and reserve, we ask you to keep $500 in that account for emergencies so that we can use it to pay off vendors should we need them to come out right away or in a timely manner. We also maintain a separate account with a security deposit. That account is holding the money that belongs to the tenant, and that money will be used at the termination of the lease to mitigate any damages by the tenant above and beyond normal wear and tear. We'll talk a little bit more about that later. Broker's authority, collection of rents and other receipts, broker's authority. You give us the authority to collect rents and other fees, and also whatever special charges may be required. You also authorize us to handle that security deposit and then to distribute it, disperse it in accordance with NRS Chapter 118. Now this is important because there are rules that we have to use to disperse the security deposit. We can't just arbitrarily assign it. There are rules we have to follow. It says any interest earned on any of these accounts goes to us, but none of these accounts are interest bearing, just so you know. Disbursement of rents, operating expense. From the trust account, we're able to pay for any and all required operating expenses. If you want us to pay some of your bills, we will do it. In our case, we ask that you give us a copy of that bill. We won't pay bills arbitrarily. We need to see a copy of the bill. They're saying you need to give it to us at least 30 days in advance. It also says here that even mortgages, we don't pay mortgages. We don't want to hold that responsibility for you. But I will remind you that you should probably stay at least a month ahead on all those monthly recurring expenses when you have a property that's under management, because sometimes the tenant might be late, and I don't want you to be late as a result of that. So stay a month ahead on your own payments. Net proceeds, every month we would give you a distribution beyond whatever balances we have to maintain. The net proceeds would go to you, and we promise to deliver that to our landlords by the 15th of every month, barring any unforeseen circumstances. And we're not required to advance any funds on your behalf. You can't ask us to lay out money for you on your behalf. Excuse me. Moving on. Again, you're going to be initialing the bottom of every page. Moving on to page 4, the IRS. The IRS will require us to deliver to you a 1099 at the end of the year showing you all the proceeds. And you need to deliver us immediately upon signing this agreement a W-9. And I'm not even allowed to distribute funds to you until I get that. So that W-9 basically has your tax information, where that 1099 is supposed to be distributed, what tax ID number you want us to use. If it's your personal one, or maybe you have a separate one for an LLC or a trust or something of that nature, which is fine. Every month we shall report to you the monies, and at the end of the year we shall produce a 1099. If you're a foreign national, you're subject to FERPTA laws. We have to do additional withholding depending upon the specific circumstances. Leasing and renting. Now, here's where you're telling us here. Before I get to that, you're telling us that you're not a non-residential. You're not a foreign corporation or partnership. You are in fact a U.S. citizen or using a U.S. entity to control the finances of this property. You are giving us the authority to rent the property, to enforce the lease, and to manage it. And then we would set up maintenance and review of the property upon occupancy, upon vacancy. And we do, actually at Brown Blankfeld, we do one every 6 months into the property, just to review the property to make sure it's in good order. And if we go in there and we see everything's in good order, great. If we see there's a problem, we're going to let you know about it. You're also authorizing us to use a lockbox, in this case an electronic lockbox. Later on in this agreement, you're going to see where I ask for permission to also use a mechanical box when it's vacant, so that we can let vendors access it when they need to during the transitional periods. Moving down, here it says that you do allow us to use one-day codes. If we put an electronic lockbox on the property and we need to let a licensed contractor, some professional licensed contractor to get into the property, you're letting us do that. But only with licensed professionals. We're not going to let anybody in there. And we're going to know who it is, and we're going to distribute those one-day codes very, very carefully. You know that we will be using multiple lists to market your property, and then therefore we'll be sharing data with multiple lists. This whole section 11 talks about opt-outs. This is if you didn't want us to use the internet to market the property, you could ask us to exempt the property or certain elements of the property, including just maybe the address or commentary or automated values, things of that nature. We're going to ask you not to do that. We're going to ask you to just let us market it fully on the internet. We're going to encourage you to do that. Again, we're going to be I initial here, owner's initial over here. Moving on to page 6, we're grinding right through this thing. This is great. Ordinary emergency maintenance repair. We are asking you to give us approval to do any necessary repairs up to $500 without your permission. And we're going to get these done in a timely manner. If it's over $500 or more, we will ask for your permission, except when it's an emergency. If there's a safety issue or the suspension or there's a law involved, emergency repair, so we made it at your expense, but with our approval. We can do that in an emergency. If the hot water heater busted and we need to get it fixed, we're going to get it fixed, even though it's going to probably cost more than $500. Smoke detectors, you need to have smoke detectors in your home. That's the law, that's a requirement. Utilities and services. Utilities are to be maintained by the tenant or the owner. We will not maintain utilities for you. We can't really do that. We ask that you take care of that. So with the utility services, you can set them up as a quote-unquote landlord policy, and I would encourage you to do that, so that should the tenant ever not maintain them, it would automatically go back to you. Then if that does happen, you let us know, and we will extract that money from the tenant, either from a security deposit or add it to their monthly rents. Insurance, you need to maintain insurance. What this says in this whole thing is that insurance is very important, and you need to have at least $500,000 of liability associated with the property as a landlord of the property. But if you were ever to lapse in insurance, or we were not be able to get any updates on the insurance, we're not obligated, but we could, in fact, obtain insurance on your behalf and then have you pay that bill out of your proceeds. We've never had to do that, don't want to do that. Just make sure you maintain your insurance. Very, very important. Again, we're all initialing at the bottom, and this is asking you to initial even here to acknowledge the importance of that additional clause with regard to insurance. Here you're holding us harmless with any specific knowledge and or any lawsuits. We assume no liability. These sections, all of these sections really relate to the idea that you still are the homeowner. We're simply your agent. The financial well-being of the property may be our concern, but you have to maintain it, and you have to spend the monies necessary to do so. If there was anything related to the environmental issues around the property, you are responsible to fix those quickly. We don't want the tenant to get sick in any way, shape, or form. If we would need to retain the services of an attorney, then you would share in that expense. You would basically cover that expense. We've never done that. We wouldn't do that. We wouldn't anticipate doing that. But if we needed to, we would ask you to take care of that expense if it becomes necessary. If it becomes necessary for all of our landlords and we can have it shared amongst the landlords, we would certainly do that. Basically, representation is just saying that you do, in fact, own the property and you have the authority to lease it. You are representing that there are no monthly expenses in default. Everything's being paid and it's current. And you're also saying here that if you were to get involved with foreclosure or anything related to a civil fine or criminal proceedings, you would let us know. And they're asking you to initial here to acknowledge that as well. Of course, again, we're all initialing at the bottom of the page. Once again, we're up to page 8. Multiple listing service. They're not a party to the transaction, although we will be utilizing them to market your property. Common interest community. If you're in an HOA, I think it's really important that you understand that we need to pass on those CC&Rs to the tenants. We will hold the tenant accountable for maintaining the property, and should there any fines or fees come, we will pass that on to the tenant. But ultimately, if the tenant defaults or whatever, you will be responsible for that. But we will see to it. In the lease, it provides that the tenant takes care of any fines or fees related to mishandling of the property in some way, shape, or form. If they leave the trash cans out too long and the association decides to fine, the tenant will be responsible for that, as long as there's a tenant there. Termination, this agreement automatically renews yearly, unless you give 30 days, unless either one of us gives 30 days notice prior to that renewal. But if you decide you want to terminate it early, you can, but there's a $250 fee to terminate this agreement early. You are responsible for any monies due at the end of the agreement. If monies were to pop up after we terminated and everything's settled, we have the right to charge additional fees if necessary. It's never happened, but it's in the agreement just to protect us from dealing with long-term follow-up financial issues. The leasing fee survives. If you were to lease the property after letting us go, we still have 90 days from the time of the termination agreement to collect our leasing fee. Indemnification survives termination. Basically what this says is that all provisions of the agreement that require the owner to insure, to defend, or reimburse, or indemnify the broker shall survive the termination. In other words, even if you decide not to continue with us, a lot of this agreement still stays in force. The rights are cumulative. We agree to mediate. We would agree to mediate if there's a dispute between any of the parties. We would all agree to mediate first. No one's relinquishing their right to sue, but we'd prefer to go through mediation first. Headings. These headings are just simple abbreviations meant to make things easy to find. Waivers, modifications, again, anything that we want to change has to be in writing, written contract. Okay. Neither party can assign this agreement without the permission of the other party. I can't hand your management over to somebody else, and you can't have someone else take over the property or responsibilities without my approval, vice versa, or my broker's approval, I should say. All notices need to go between those two contact categories we had on page 1. If part of this contract at any point is deemed invalid, it doesn't invalidate the whole thing. Publicity, neither party shall make any public announcements concerning the agreement without the permission of the other party. Again, we're initially at the bottom of this page. Any waiver or default or breach or failure to perform under this contract shall not be deemed a waiver or subsequent default, breach of performance. And we could, just because we decide to waive something now doesn't mean we have to waive it every time in the future. That's what that simply means in my mind. Applicable law, this contract is written in the state of Nevada, and it should all Nevada law should apply. This complete agreement, basically what it says is what's written is what counts. What I'm saying by way of explanation doesn't really count, even in this video. It doesn't really count. It's just a simple explanation of it. Well, what's written is exactly what counts. And anything, again, that's changed in this has to be in writing. Signatures could be either manual, digital, or facsimile. Additional terms, I think I mentioned this before, but if a landlord with us has 3 or more properties, we reduce our rates to 8%, or a minimum of $80 per property. If the landlord also understands that if a tenant vacates the property and doesn't leave sufficient funds to cover the repairs of the back rents, we will provide support to you, to whomever you decide to have collect that debt. We don't pursue the bad debt beyond the tenancy. That's not something we can really do. But we will support you and help you with all the documentation necessary to collect that fee. The $300 referral commission is part of the $800 leasing fee. So I'm just clarifying that it's not addition to that. And finally, under certain circumstances, we will use a mechanical box sometimes on the home, particularly when it's vacant, to accommodate vendors. This is the signature page. I sign here. Our broker signs here. You homeowners would sign right here. Of course, we would all date this. And again, we initial at the bottom of the page, as we do on the bottom of every page. This is now Exhibit A. And in Exhibit A, we're identifying the specifics of the property. The property address is right up top here. This is the property we're going to be managing. This is the date we just did this agreement. Excuse me. Then if there is a tenant, that information would be here. Here's the minimum rent that the landlord's expecting for a minimum of 1 year and a maximum of 2 years in the initial term. Usually we just do 1 year leases. Every now and then, if a landlord agrees, we will make it a 2 year lease. It's nice not to have to deal with a renewal after 1 year, but sometimes expenses go up and we don't want to lock you into a certain rate. Will pets be considered? Will smoking be allowed? Will Section 8 be allowed? Here's the mailbox number of the property, the gate code of the property, the parking space number of the property. Now this is really important. This is the insurance information. Here again, we need to be named as additionally insured on the property. This is your insurance information, the policy number, the company, the contact information, and you're validating that yes, you are naming us as additionally insured. Here we have a warranty also, a home warranty on the property with the policy number and the contact phone number so that we can reach out to them for any repairs necessary in the property. That is our property management agreement. I hope this was helpful. If you have any questions, by all means, just give us a call. I hope you found this video helpful. Feel free to review our other videos at www.brownblankfeld.com. Once again, thanks for choosing the Brown Blankfeld Group for your real estate needs. And if you ever have any questions, just call or text at 702-203-1165.